हौसला मंद हो और कोशिश कम न हो, मुश्किलें खुद ही रास्ता देती हैं. Welcome back, my UPSC warriors, to yet another session of Target Prelims 2024. So yesterday we had our very first session, and I hope you have performed well. And even if you have not, please don't sweat over it. Why? The whole point of this exercise is to perform and improve and be better every day. Target Prelims knows that the path to success is not always going to be a straight shot. But hey, we are in this maze together. And always remember, champions are never built overnight. It's about focus, it's about consistency, and it's also about this unwavering belief that you can do it. Tonight's session is another brick in your UPSC foundation. We'll be diving deeper and sharpening our swords on some more questions, this time from the legislatures. So fuel up with some motivation and of course some chai or coffee and get ready to dominate that prelims beast. Remember, every session and every question conquered brings you closer to your dream. Let's keep the momentum going and write your own UPSC victories. This is session 2 for Indian Polity Target Prelims 2024. We have the schedule. I had shared this yesterday as well. In case you want to plan your revision, you can follow this schedule accordingly. Let's begin now with the very first question, number 1. Consider the following statements. The Electoral College for Rajya Sabha comprises of all elected MLAs of the state. Number 2. A candidate contesting an election to the Rajya Sabha from a particular state should be necessarily an elector in that state. And number 3, all states and UTs have representation in the Rajya Sabha. Now, statement 1 is correct. This is mentioned under Article 80, Clause 4, that the voter list comprises of all the elected MLAs of the state. And what's the system of voting? Proportional representation by means of single transferable vote. So 1 is correct. Now when you come to number 2, there's a small problem. This statement was correct till 2003 because in the year 2003 RPA was amended and this criteria was removed. I think we had discussed this yesterday as well, that in case you want to represent any state in the Rajya Sabha, you need not have your name in the voter list in that state. You can be a voter anywhere in the country and still represent any other state as well, right? So elector meaning voter. So voter in that state is not required. 2 is wrong. And number 3, all states and UTs have representation in the Rajya Sabha. Is that correct? Of course not. States, yes, states have representation in Rajya Sabha, but not all UTs have representation. Only those UTs which have a legislative assembly will have a representation in the Rajya Sabha. So we have UTs of Delhi, Pondicherry and Jammu and Kashmir with 3 seats, 1 seat and 4 seats. So 3 is also wrong. Now the question says how many of the above statements are incorrect, mind you. So the right answer is B, 2 only. Moving on to the next question, which of the following are the members of the Delimitation Commission? You know, under Article 82 of the Indian Constitution, we have this concept of what? The concept that the Parliament by law can decide on creating or establishing an authority which will adjust the territorial constituencies, the boundaries of the constituencies. So that authority is called the Delimitation Commission, and the members are retired Supreme Court judge, Chief Election Commissioner, and also for every state, the respective state election commissioners, right? So of course, PM is not a member of the commission as well as the Speaker of Lok Sabha, right? So these 3. Plus also remember that whenever this commission gives any award, any order, that order cannot be challenged in any court of law. Okay, so 3 and 4, which means C is the right answer. Moving on to the next question. Consider the following statements with respect to the removal of speakers. So at least 1/10 members are required to give a notice to initiate the process of removal. No grounds are mentioned in the constitution for their removal, and the voting for removal requires an effective majority. The removal of speakers is mentioned under Article 94 of the Indian Constitution. Now, there is no such provision like this that you need to have 1/10 members to give a notice for removal, just like we have for the president, that to initiate a impeachment process, the notice has to be given by at least 1/4 members of the House. There is no such provision for the removal of speakers. So 1 is wrong. But yes, 2 is correct. There is absolutely no ground mentioned in the constitution for removal of the speaker. And 3 is also correct. I think we know this, that the presiding officers and the deputy presiding officers at the central level and in the states are removed by an effective majority. So 2 and 3 are correct. Right answer is B. Only 2. Moving on to the next question. Which of the following are elected by a system of proportional representation by means of single transferable vote? Members of Lok Sabha, we know very well, members of Lok Sabha are elected through first past the post. Of course, members of Gram Panchayat are also elected directly, first past the post. Members of Rajya Sabha, Article 80, yes, absolutely correct. They are elected by a system of proportional representation by means of single transferable vote, and so are the members of the state legislative councils, at least those members 1/3 who are chosen by the MLAs. They are elected through a system of proportional representation by means of single transferable vote. So 3 is also correct. 2 and 3, B is the right answer. Moving on to the next question. Which of the following statements regarding Article 249 of the Indian Constitution is correct? So it enables the Parliament to legislate on matters enumerated in the state list if the Rajya Sabha passes a resolution supported by not less than 2/3 of the members present and voting. Now this statement seems to be absolutely correct, but let's read the other statements also. Now, once the authorization is made, the Parliament is bound to make laws. No. The Parliament, if it wants to, it may make laws. So once the Rajya Sabha has given the Parliament the permission to make laws on state list subjects, the Parliament may make laws, it may not make laws. There is no boundation, right? So this is wrong. See, such bills require the assent of the President of India before it is introduced in the Parliament. No, there is absolutely no need to have the prior recommendation of the President. And D, laws made will automatically become void once the resolution passed by the Rajya Sabha expires. No, this is also wrong. So see, when the Rajya Sabha gives the authorization, that authorization is valid for 1 year at a time. It can be extended any number of times. But once the authorization, this permission to make laws ends, the laws made, if any, also end but 6 months after the end of authorization. 6 months after, not on the same date on which the authorization ends. So this is also wrong. So we know very well A is the right answer. Okay. Moving on to the next question. Consider the following statements with respect to the Parliament of India. Fourth schedule of the Indian Constitution deals with allocation of seats in the Lok Sabha and the Rajya Sabha. See, when it comes to the fourth schedule, of course, it deals with the allocation of seats, but in the Council of States, Rajya Sabha, not the Lok Sabha. So one is wrong. Number two, as per the constitution, the elections to all the seats in the Lok Sabha are conducted via direct elections. Now we have 543 seats in the Lok Sabha. So do we have direct elections for all the seats? Yes, of course. But is that mentioned in the constitution? Yes and no. So as far as the states are concerned, yes, it is mentioned Article 81. But for UTs, it says that the Parliament by law will provide for the manner. By law meaning by a simple majority will provide. And we have made a law, and that law is called the Union Territories Direct Election to House of People Act of 1965. As per that law, elections to represent the UTs in the Lok Sabha take place directly. So we have 8 UTs. Dadra and Nagar Haveli and Daman and Diu have 2 seats. Delhi has 7 seats. Jammu and Kashmir has 5 seats. And the remaining UTs all have how many seats? 1 seat each. Anyway, so 2 is also wrong. That's the whole point. Number 3, both the Lok Sabha and Rajya Sabha have representation from all the UTs of India. Both the Lok Sabha and the Rajya Sabha have representation from all the UTs of India. See, Lok Sabha, yes. Rajya Sabha, no. I think we know very well. Rajya Sabha does not have representation from all the UTs. It's only from UTs of Delhi, Pondicherry, Jammu and Kashmir. Okay. So 3 is also wrong. How many statements given above are correct? D. None of the statements are correct. Moving on to the next question, consider the following statements with respect to amendment of the Constitution, amendment provisions under which Article 368, extremely important. We have seen multiple questions on amendment being asked again and again over the years. So, such bills can be introduced by a minister only. Really? Not required. I mean, such a bill can be introduced by a minister or any other MP also. So any MP, whether the MP is a minister or a non-minister. And what do we call non-ministers? We have a term for them, private member. They are called private members. So 1 is wrong. Number 2, the president can exercise his pocket veto in such a case. I hope you know that through the 24th Amendment Act of 1971, it has been made mandatory for the president to give assent to constitutional amendment bills. So, no scope for any veto power. And number 3, so far more than 100 amendments have been made to the Constitution. Yes, of course. In fact, with the last modification made, providing for reservation for women, that was the 106th amendment made. So 3 is correct. How many statements? Only 1. A is the right answer. Next question. Consider the following statements about money bills. It can only be introduced in the Lok Sabha. Yes or no? Yes, of course. Money bills can be introduced only in the Lok Sabha. The definition for money bills is mentioned under Article 110 and the procedure is under Article 109. Okay. Number 2. As per the Constitution, such bills can be introduced by ministers only. Yes, money bills are normally introduced by ministers only. But is this fact mentioned in the Constitution? No. This point is not mentioned anywhere. It's more like a convention, a practice that money bills are introduced by ministers only. So this is wrong. And number 3, the president shall give his assent to such bills within 14 days. Now you know that this 14-day clause is there, but not for the president. For Rajya Sabha. Rajya Sabha has no authority over money bills because ultimately you have to pass the bill. And if you don't, within 14 days, the bill is deemed to have been passed. Right? So we normally use the term Rajya Sabha has returned the bill. Done. So this is wrong. And as far as the president is concerned, the president cannot send back the bill. Right? Now, there is no time frame mentioned for the president to give assent. You might say, sir, can the president use pocket veto? Is it possible? Yes, he can, because nothing is mentioned. Now, again, logically, why would he or she use pocket veto? Because such bills are introduced with his prior recommendation. That's a separate story. But if we take an extreme stand, can he or she use pocket veto? Possibly. But can they use suspensive veto? No. Constitutionally also, it's very clearly mentioned that the president cannot, absolutely cannot send back such money bills. Okay. So 3 is also wrong. How many statements given above are correct? So only 1. A. Next question. Consider the following statements about the no confidence motion in the context of the Indian parliamentary system. It can be introduced in either house to express a lack of confidence in the Council of Ministers. And number 2, for an NCM to be admitted for discussion, it requires the support of at least 50 members of the House. Number 3, if an NCM is passed, the Council of Ministers must ideally resign from office. And number 4, Part 5 of the Constitution mentions the procedure for an NCM. NCM, no confidence motion, mentioned under Rule 198 of the Lok Sabha rules, right? So it can be introduced in either house. And NCM is brought only in the Lok Sabha. 1 is wrong. Number 2, for an NCM to be admitted, yes, 50 MPs have to support it. That is correct. Number 3, if NCM is passed, the Council of Ministers must ideally resign. Yes, because they have lost the confidence of the House. So better resign. And number 4, Part 5 of the Constitution mentions the procedure for an NCM. NCM is mentioned under Lok Sabha rules and not under the Constitution. Motions in general are not mentioned in the Constitution. So, no, this is also wrong. 2 and 3 are correct. How many statements are correct? B. Only 2. Next question. With reference to money bill, one more question on money bill. Consider the following statements. All financial bills are money bills, but not all money bills are financial bills. Let's draw a Venn diagram. So if this is where you have all the financial bills, money bills are a type of financial bills, right? So it would be somewhat like this. Because we have some other types of financial bills also, which we call as financial bills type 1 or type 2 under Article 117. So money bill is a type of financial bill. This means what? All the money bills are financial bills, but not all financial bills are money bills. So this statement is wrong. It's the exact opposite. And number 2, joint sitting for passing money bills is presided by the speaker. That is correct, that joint sitting is presided over by the speaker. We fully agree on this. But since there is no possibility of a deadlock on money bills because Rajya Sabha has no power over money bill, so there is no concept of joint sitting in the case of money bills. So both statements are wrong, and the question, please read carefully, which of the statements given above is or are what? Incorrect. So both 1 and 2 are incorrect. C is the right answer. So that's there. Moving on to the next question. Consider the following statements. A censure motion can be moved against an individual minister or the entire council of ministers. That's the first point. Number 2, unlike a no confidence motion, a censure motion does not need to specify the grounds on which it is moved. So a censure motion can be moved against an individual minister or the entire council. Is this correct? Yes, of course. A censure motion can be moved either against an individual minister or the entire council. Fair enough. Now, unlike an NCM, a censure motion does not need to specify the grounds. Sadly, it's the exact opposite. When you bring a no confidence motion, feel free to not give a reason. In fact, even if you try to give a reason, that reason is not a part of the formal motion. However, censure motion can be brought with a proper reason only. So, second one is wrong. The passage of a censure motion requires the government to resign. Nothing of this sort happens. If you bring a censure motion, what's going to happen? It's like censuring the government, reprimanding, formally scolding the government. So, should the minister resign? He should, morally. But will he resign? Of course not. Why will he resign? So, nothing of this sort is expected. So, this is wrong. And number 4, a censure motion can be moved only in the Lok Sabha. This is correct. 4 is correct. So, which of the statements are correct? 1 and 4. A is the right answer. Next question. Consider the following motions. Calling attention motion, privilege motion, censure motion, adjournment motion. Calling attention motion, privilege motion, censure motion and adjournment motion. Now, how many of these motions can be introduced in either house of the parliament? So, there are certain motions which can be introduced only in the Lok Sabha, like no confidence motion, only in the Lok Sabha, like a confidence motion or also called the trust vote, only in the Lok Sabha, like censure motion only in the Lok Sabha, adjournment motion only in the Lok Sabha. Whereas other motions like a calling attention motion, privilege motion, motion of thanks, they are introduced in both the houses, right? So here, how many can be introduced in either house? These two. B is the right answer. Next question. Consider the following statements related to the legislative process in the state legislatures. A money bill can be introduced only in the state legislative assembly. Yes or no? Yes, of course. Money bills, lower house only. So 1 is correct. Number 2, an ordinary bill, if passed by the legislative council but rejected by the assembly, ends up in a deadlock. Now, if this statement was at a central level, it would have been correct. Of course, an ordinary bill, if passed by, let's say, one house, Rajya Sabha, and rejected by the Lok Sabha, ends up in a deadlock. But sadly, there is no concept of joint sitting at the state legislature level. We know very well, legislative councils can only delay the passage of bills for how many months? 3 + 1, maximum 4 months. So there is no deadlock. If the assembly rejects a bill, the bill is dead. And number 3, in case of a deadlock in the state legislature, the governor can call for a joint sitting. There is no concept of joint sitting, sadly. So which of the statements given above is or are not correct? So the answer is B, 2 and 3. Next question. With reference to the enactment procedure of the union budget, consider the following statements. The budget is presented by the Union Minister of Finance before a joint sitting of both the houses of the Parliament. The budget is presented by the Union Finance Minister, yes, of course, but in the Lok Sabha, not before a joint sitting. This is wrong. Cut motions can be raised only in the Lok Sabha. So we have three different types of cut motions, right? One such cut motion is a economy cut motion. Then we have the token cut motion, and the biggest of them all is the disapproval of policy cut motion. These cut motions, since they are a part of the voting on demand for grants, this can only be done in the Lok Sabha. Absolutely correct. Number 3, the speaker can put demands for grants to vote irrespective of whether they have been discussed or not. Yes, that is what is called the guillotine closure. Guillotine. So what is the meaning of this? It means that while the discussions are going on, at any point of time the speaker can say enough discussions, let's put all the matter to debate, even without discussing all the clauses of a bill or a proposal. That's possible. Guillotine closure. So this is correct. So 2 and 3 are correct. How many statements are correct? B, only 2. Next question. Which of the following statements about parliamentary privilege in India is incorrect? So A, parliamentary privileges include freedom of speech in the parliament and immunity from legal proceedings for anything said or any vote cast within its chambers. Yes, of course, that's the meaning of parliamentary privilege. Article 105, right? B, MPs are exempt from criminal proceedings during a parliamentary session under parliamentary privilege. MPs are exempt from civil proceedings. Section 135 capital A of the Code of Civil Procedure 1908. Civil, not criminal. So this is wrong, which makes it the right answer. B is the right answer. Let's read the other points as well. The Indian Constitution does not enumerate all the privileges granted to MPs, and the breach of privilege is an offence that is determined by the presiding officer of the House and can lead to punishment as decided by the respective House. That's correct. So statements A, C and D were correct. B was wrong, hence the right answer. Next question. Consider the following assertion. So it's an assertion reason based question. No member is liable to any court proceedings for any vote given within the precincts of the House. Precincts, boundaries, right? The floor of the House. Even if the member has accepted a bribe to cast his or her vote. Interesting, right? Reason. The purpose of parliamentary privileges is to ensure that members perform their duties without fear or favor, affection or ill will. See, reason is correct because it's also the part of their oath that the ministers take, the oath of office. Under which schedule? Schedule 3. However, this assertion is wrong. Recently, there was a judgment, Sita Soren case of 2024. And in this judgment, Supreme Court said that there is no immunity given under Article 105, Clause 2 or Article 194 for the state legislators in case of bribery. So yes, we know that for anything said or any vote given on the floor of the House, you will not be liable to any court proceedings. But if you take a bribe to go and cast your vote in the House, then though that particular vote is subject to the regular court proceedings, right? So assertion is factually incorrect. So right answer is D. A is incorrect, but R is correct. Next question. Consider the following statements about the anti-defection law in India. ADL. The speaker can only act on complaints and cannot take suo motu action. And number 2, the whip is a constitutional office mentioned under the 10th schedule. Is whip mentioned under the 10th schedule? What is whip? Whip basically is the instruction given by the party to all its legislators to vote in a particular direction. That's called whip. We have various types of instructions, like we have the concept of single line whip, double line whip, 2-line whip, or a 3-line triple line whip. So in a single line whip, what happens? The party tells you that on a particular date, voting on a bill is going to take place. Whether you want to attend or not, that's up to you. How do you want to vote? Your choice. 2-line whip says that on that particular date, voting is going to take place and you better come and vote. How? Yes, no, abstain, your choice. 3-line whip is the one where you are informed that on a particular date, voting is going to take place. Please come and also vote in the direction that the party wants you to. So press the green or the red button accordingly, right? That's a 3-line whip. This whip has been inspired from, of course, UK, but this is not mentioned in the constitution. Whip, by the way, is also the person from the party who has been given this responsibility to ensure that all the legislators get this information on how and when to vote or in what direction to vote. So the whip is also the person who ensures that this whipping system is executed properly. Okay. So 2 is wrong. First one, can the speaker act on his own? Not really, because Schedule 10 very clearly says that any disqualification issues will be referred to the presiding officer, and once it is referred to the presiding officer, only then will he act. In fact, there has been a Jharkhand High Court judgment on this as well, Babulal Marandi case of 2020, right? So this statement is absolutely correct. The speaker cannot take action suo motu. Some party has to go and complain about a possible anti-defection law violation, right? So 1 is correct, 2 is wrong. Which of the statements is or are incorrect? Right answer is B, 2 only. Next question. Consider the following statements about Public Accounts Committee of the Parliament. It was first set up in 1921 under the provisions of the Government of India Act 1990. Public Accounts Committee, Committee on Public Accounts. It's a part of Lok Sabha rules, of course, not mentioned in the Constitution. So you will find this under Rule 308. Rule number is not really important, but still. So Rule 308. Yes, it is the oldest committee and of course was set up in 1921 under the provisions of the Government of India Act 1919. Absolutely correct. It has currently 22 members, all from the Lok Sabha. So normally we have 2 types of committees, a joint committee, a select committee. A joint committee is a committee which has members from both the houses. Most committees are joint committees only, right? At least the permanent ones. And then we have select committees. Select committees are those committees which have members from one house only. And the very classic example of a select committee is Estimates Committee, which has 30 MPs or members, all from the Lok Sabha. PSC is not a select committee. It's a joint committee. It has 22 members, yes, of course, but 15 of them come from Lok Sabha and 7 come from Rajya Sabha. 2 is wrong. Number 3, its members are chosen according to the principle of proportional representation. Yes, absolutely correct. And number 4, the chairman of the committee is invariably from the opposition. Yes, that's also true. By the way, this has been true only since 1967. You will be surprised to know that prior to 1967, in fact 1948 to 1950, the finance minister used to be the chairman of the PSC. It's hilarious because the task of the PAC is to evaluate government expenditure, and finance minister being the chairman of this committee was nothing short of complete violation of natural justice. Anyway, from 51 to 66, the ruling party MP used to be the chairperson, but thankfully better sense prevailed in our amongst our MPs, and now the chairman is always from the opposition party. So this is also correct. 1, 3 and 4, three statements are correct. Right answer is C, only 3. Next question. The provisions of ADL, Anti-defection law, 10th schedule of the Indian Constitution does not apply to members of the House who are a part of Council of Ministers. Really? If a minister leaves his party, will he or she not be subject to disqualification? Of course, he or she will also be subject to disqualification. Wrong. B. Members who have not been elected as the leader of the legislative party. Utter nonsense. Every legislator is equally subject to anti-defection law except this. The presiding and the deputy presiding officers are exempt from ADL. So in fact, we wish that our speakers would resign from their party once they become speakers. Why? So that they can be more independent. They don't do it is a completely different story. But it has been added as a provision to ensure that if at some point of time some person who becomes a speaker wants to be independent, be seen as independent, he or she can leave his party and will yet not be disqualified. Mind you, but once you leave your party, you can't join your own party back or any other party till you hold the post of the speaker. That's it. So C is the right answer. And D, a member giving up the membership of his original party voluntarily. Of course, that's a classic case of disqualification under ADL. Next question. It can be moved against an individual minister, a group of ministers, as well as the entire Council of Ministers. Interesting. It means an expression of strong disapproval or harsh criticism. It can be moved in the lower house or in a state assembly in India. Which of the following motions is described in the paragraph given above? Okay, so let's read once again. It can be moved against an individual minister, a group of ministers, as well as the entire Council of Ministers. If it can be moved against a group of ministers or a single minister, then sadly it is not a no confidence motion. Now, it means an expression of strong disapproval or harsh criticism, okay, and it can be moved in the lower house only. So lower house only meaning what? Calling attention motion goes away. This also goes away. Plus anyway, if it is being moved against ministers only, this goes away. So what remains is censure motion. D is the right answer. Next question. Consider the following statements regarding DRSCs, departmentally related standing committees, right? So just some brief information. DRSCs are under Lok Sabha rules, Rule 331 capital C. Now, these rules were not, or the DRSCs were not a part of the Lok Sabha rules initially. In fact, they have been a more recent addition. So the rules were added in the rules were modified in 1993 to incorporate DRSCs. Originally, we had only 17 DRSCs. Now we have 24 DRSCs. Every DRSC has some MPs from Lok Sabha, some from Rajya Sabha. So 22 MPs from Lok Sabha, 10 from Rajya Sabha. Okay. Out of these 24 DRSCs, 16 work under the control of the speaker and 8 work under the control of the chairman. Now, DRSCs comprise of MPs from both houses. Yes, absolutely correct. 2. Ministers can become members of DRSCs, but the chairman must belong to the opposition party. Both statements are wrong. So, number 1, ministers cannot become members of DRSC. This is wrong. Chairman must belong to the opposition. Nothing is specified. The presiding officer decides on the chairman's post. This is also wrong. 2 is wrong anyway. Number 3, DRSCs were not a part of the original rules adopted in 1952 and were a later addition. Were they a later addition? Yes, of course. 1993. This is correct. So 1 and 3 are correct. Which of the guys, please focus. Not how many. Which of the statements is incorrect? Which statement? So 2. 2 only is incorrect. Please. Not how many. How many? 1. Which? 2 only. Okay. Next question. How many of the following provisions have been explicitly, clearly mentioned in the Constitution as a ground for disqualification for being elected as a member of Parliament? So disqualification for MPs is mentioned under article, which article? 102. Okay. Clause 1 and clause 2. Clause 2 is for ADL. Clause 1 has certain provisions. So holds an office of profit. Office of profit. Yes, of course. In fact, if you look at article 102 clause 1, the very first subclause A is office of profit, a disqualification. Then you have unsound mind, clause B. Then you have undischarged insolvent. This is subclause C of the same clause. So this is also there. And then you have subclause D, which talks about not being a citizen. Okay, these are the 4 disqualifications. And of course, subclause E says that we can have more disqualifications depending on a law made by the Parliament. A very good example is a law called RPA 1951, which has various sections which talk about disqualifications. Number 3, punished for preaching and practicing social crimes such as untouchability, dowry and sati. Now this is not explicitly mentioned in the Constitution but is mentioned under RPA, hence this is not a part. 1 and 2 are correct. Select the correct answer. Only 1, only 2, all 3. B. Only 2 of them have been mentioned clearly in the Constitution as ground for disqualification for being elected as member of the Parliament. Next question. Consider the following statements regarding the special session of the Parliament. Special session of the Parliament recently seen in the news. Unlike regular sessions, special sessions of the Parliament can be summoned by the Speaker of Lok Sabha. Why? Every session will be summoned by the President. Article 85. Who will summon the session? The big boss. Who will prorogue the session? The big boss. 1 is wrong. Guidelines for conducting special sessions are mentioned in the Lok Sabha and Rajya Sabha rules. Nothing is mentioned anywhere, right? In fact, we don't even have a proper calendar, right? Unlike some countries, say UK and Australia have a proper calendar, right? You have for the UPSC. UPSC has a calendar where you know very well next year when is the form filling date going to start, when will the notification come out, when will you have your prelims, mains, etc. And for various exams that it conducts. Parliament has no such official calendar. Right? We normally have 3 sessions: the budget session, the monsoon session and the winter session, BMW. Any session beyond it can be termed as a special session, right? So we can call it a special session because it is an unusual one, beyond the normal. That's it. Number 3, presiding officers of the respective house can limit the use of question hour during a special session. Yes or no? Of course. Question hour, complete control of the presiding officer. So 3 is correct. How many statements are correct? So we know only 1. A is the correct answer. Next question. The concept of a joint sitting of Parliament in India is applicable in the case of, number 1, money bills. Joint sitting inspired by the Australian Constitution. Article 108 of our Constitution talks about joint sitting. Money bills, no joint sitting because Rajya Sabha has no power. Ordinary bills, yes, of course, joint sitting possible. Constitutional amendment bills, do we have joint sitting for such bills? such bills must be passed in both the houses separately, right? No concept of joint sitting. So this is wrong. This means B is the right answer. Under which of the below circumstances can the parliament make laws on state subjects? Interesting. So just to quickly recap, there are certain situations where the parliament can make laws on stateless subjects. Number one, we know Article 249. When the Rajya Sabha authorizes the parliament, if it is expedient or urgent in national interest, it can be done. Or during a national emergency, it can be done. Or when two or more states request, then it can be done. Or to fulfill some international treaty obligation, etc. Or in a particular state, if there is President's rule in that state, Article 356 and the provision under 357. These conditions. Let's check. When Lok Sabha passes a when Rajya Sabha passes the resolution, so one is wrong. Remove it. During financial emergency, yes or no? Not really. This is also wrong. When states make a request, yes, of course, Article 252. To implement international agreements, yes, of course, Article 253. During President's rule, yes, of course, Article 357. So 3, 4 and 5. B is the right answer. Next question. Consider the following statements about the disqualification of legislators for conviction of an offence. Disqualified legislators, number one, can never contest an election from the date of, that's too harsh. Never contest. There has to be a time period for punishment. How can you disqualify somebody forever? No. Once the punishment period is over, you become eligible to contest again. So there is a time period. Various sections under various laws have time periods. So if you look at RPA, chapter 3, which talks about disqualifications, section 8 talks about the disqualification for the jail term plus once you come out 6 more years. 8A talks about disqualification for not more than 6 years, maximum 6 years. 9 says 5 years. Then you have 9A and 10, which state that as long as you hold a government contract or as long as you hold a particular office, you will not be allowed to contest. And then we have 10A, when you fail to lodge the account of expenditure or you exceed what? The expenditure limit. So currently the maximum permissible limit of money that you can spend in your campaigns is 95 lakh rupees for the larger constituencies. I know what you're thinking, 95 lakhs is a big joke, but anyway, laws are laws. If you cross this amount, you can be disqualified by the ECI for up to 3 years. So this time period varies. One is wrong. Number two, disqualification cannot apply if the offence is a petty offence, inviting punishment of less than 2 years. This is true actually, because if you look at section 8, subsection 3, disqualifications for such petty offences, if they are less than 2 years or if the punishment is less than 2 years, are not available. You are not disqualified if you are in jail for less than 2 years for a petty offence. 2 is correct. Number 3, offences mentioned under section 8(1) of the RPA 51 will invite disqualification even for conviction without a sentence. Yes or no? Of course, absolutely correct. So this is 8(1) where you have, if there is a jail sentence, that's included, but even if somebody imposes or the court imposes a monetary fine on you, you will still be disqualified for 6 years. For example, let's say Protection of Civil Rights Act. 1955, right? This is the law wherein we punish for the offense of untouchability under Article 17. Now, this law allows for jail sentence, also imposition of monetary fine. Let's say you practice untouchability and you are found guilty and monetary fine has been imposed on you, no jail sentence. Even then, you will not be allowed to contest elections for 6 years. So 3 is also correct. This means how many statements are incorrect? Let's not forget incorrect. So only 1. A. Next question. Consider the following statements with respect to the suspension of MPs in India. Suspension of MPs. Last year we had the suspension of MPs in the House, right? Hundreds of MPs being suspended. That was a very historic moment in our country. You know, when such things happen in other countries, like say in the British Parliament, since 2019, 25 MPs were suspended, and people were already labeling that as the worst parliament in the history of Britain. And we are suspending over 100 MPs on in a matter of couple of days, right? So that's it. Anyway, the Speaker of the Lok Sabha can suspend an MP for disorderly conduct without a vote in the House. Let me just give you a brief on this suspension concept. So we have this suspension under Lok Sabha rules. Lok Sabha rules. So there are 3 rules: 374, 374A, and there's one more rule, 373. So 373 is a rule under which the member, the MP, is asked to withdraw from the House for disorderly conduct for 1 day, right? So get lost for today, come back tomorrow. That's it. Now 374 is a more serious one, wherein if you misbehave, you will be named. An MP is named, meaning he's pointed out that you are misbehaving, and a motion can be raised, and then the House votes on it. And if it is passed, you will be suspended from attending the sittings for the entire remaining period of the session. Okay, the session. 374. But 374 requires voting in the House. We have something called 374A also. This was added later on, 2001, 5th of December. A very unique concept by GMC Balayogi, the speaker. If you remember, he passed away in that Bell helicopter crash. Anyway, so this 374 capital A was added. Herein, speaker has a power that the presiding officer, if he names an MP that you are misbehaving, stupid fellow, then what happens? Automatic suspension for at least 5 days or the remaining session, whichever is less, right? So that's there. So yes, the Speaker of Lok Sabha can suspend under 374A even without a vote in the House. It's allowed. 1 is correct. Similar provisions exist in Rajya Sabha also. In Rajya Sabha, there is a small point of difference. For 373, we have rule 255, okay, wherein for 1 day, the MP is told to get lost, to go home. And for 374, which involves what? Voting, we have one rule 256. Sadly, there is no such corresponding rule like 374A. Because 374A gives the presiding officer, the Speaker of Lok Sabha, unique power. This does not exist in the Rajya Sabha. Rajya Sabha suspensions require voting also. That's it. Anyway, so 1 is correct. Number 2, a suspended MP while not eligible for a daily allowance. You know very well, every MP gets, apart from his salary, a daily allowance. So when you are suspended, you will not get any daily allowance. That's effect number 1. As if our MPs depend on allowances to survive. No, of course they do. Honest people, right? So a suspended MP will not be eligible for daily allowance is correct, but can still take part in the parliamentary committee meetings of which he or she is a member. No. Once you are suspended, no daily allowance, number 1. Number 2, you cannot take part in the parliamentary committee meetings also of which you are a member, right? Let's say you are a member of some DRSC on health. You can't take part in those meetings till you are suspended. And number 3, you cannot also give any notice for any kind of proposal, etc. That's also not there. So 2 is wrong. So which of the statements is correct? We know very well right answer is A. Only 1 is correct. Okay. So this is for the suspension. Of course, so you'll always have issues on suspension. Some people always raise a concern that suspensions are highly subjective in nature. It depends on the subjectivity of the presiding officer. I'll give you an example. Satya Gopal Mishra, back in July 1989, a debate was going on the CAG's report, and Satya Gopal Mishra, he dislodged through the mic of the speaker and was yet not suspended, just scolded. So it depends. I mean, in your school days also, some teachers will not scold you for talking. Other teachers will almost murder you for talking in the class. It's subjective, very subjective. Anyway, so next question. Consider the following statements. While an adjournment motion in the Lok Sabha requires the support of 50 MPs, the adjournment of daily agenda in the Rajya Sabha under Rule 267 can be moved by a single MP. A very interesting point. So you have adjournment motion which is only in the Lok Sabha. Such motions can be brought in the Lok Sabha only, right? Which means what? Something very urgent has to be discussed, of national importance. Of course, matters which are sub judice, under court, they can't be discussed. So what you will do is you will suspend the entire agenda of the day. Whatever was going to happen, you suspend all that and then you discuss on that matter for at least 2.5 hours. Minimum debate time is 2.5 hours. There is no similar motion in the Rajya Sabha. What if the MPs of Rajya Sabha want to discuss on something very urgent, but there is already a schedule on what has to be discussed on that day? Then what to do? So there is a concept of Rule 267. Difference being that in the adjournment motion, 50 MPs have to support the notice. Only then can the notice be accepted by the speaker. Whereas under Rule 267, any MP can move such a notice. So 1 is correct. Number 2, an adjournment motion can be moved only with the prior permission of the speaker, okay? Whereas a motion under Rule 267 does not require the prior permission of the chairperson. This is wrong. If you want to raise any motion under Rule 267, you have to take the prior permission of the chairperson. This is wrong. In the 17th Lok Sabha, no adjournment motion was discussed. That's true actually. In the both 16th Lok Sabha, when was the 16th Lok Sabha? The timeline was 2014 to 2019. And the 17th Lok Sabha was the last one. That is 2019 to 2024. In fact, in both these Lok Sabhas, not a single adjournment motion was discussed. Though we saw 2 NCMs. Very interesting. No confidence motions were introduced both in the previous Lok Sabha and this Lok Sabha. Once in 2018, that was the then monsoon session, and this time also 2023 monsoon session. Both the occasions. Anyway, so yes, 3 is correct. Right answer. How many statements are correct? B. Only 2. Next question. Consider the following statements about the recently passed 106th Amendment Act to the Indian Constitution. 1/3 of the seats in the Lok Sabha and state legislative assemblies, including the Delhi Assembly, are to be reserved for women. Yes or no? Yes, of course. That's the whole amendment. Correct. The validity of this reservation is set for 15 years. Yes, absolutely correct. Just like the validity for the SC reservation, ST reservation, Anglo-Indian nomination, it was all set for 10 years. But we have modified the constitution and have been extending it till 2020 for Anglo-Indians and right now till 2030 for SCs and STs. But it can be extended by amending the constitution. No. In fact, this has been made more lenient. So the reservation for women is meant for 15 years. You can extend this provision, but that does not need any kind of modification under Article 368. All you need is Parliament by law. It can be extended by Parliament by law. Simple majority. Number 3, reserved seats for women will be rotated after each delimitation process. Yes, of course. Just like, you have the reservation based on rotation for what? Panchayats, municipalities. Similarly. Correct. Number 4, the commencement of this reservation will take effect after the publication of the 2021 census. That's not the provision. The provision is very simple. It says that the reservation will be effective after the census conducted after the commencement of this act has been published. So when this act is published, then whichever census is conducted after that census is conducted, we'll begin this policy. Now, whether it is going to be 2021 census or 2031 census, only God knows, or the government knows. So it's not 2021 census. It will be any census which is published after, or rather conducted after the publication of this act. 4 is wrong. So how many of the above statements are correct? 2. B. Only 2 is the right answer. Next question. How many of the following is or are the special powers of Rajya Sabha? Special powers of Rajya Sabha: authorizing the creation of new All India service. Yes or no? Yes, of course. Article 312. Authorizing the Parliament to make laws on state list subjects. Yes or no? Yes, of course. Which article? 249. Authorizing the Parliament to take away the fundamental rights except 20 and 21 during a national emergency. What kind of provision is this? See, this is actually 359. Article 359, if you remember, says that in case a national emergency is in force, has been proclaimed on any reason, any ground, war, external aggression, or armed rebellion, it does not matter. The President can issue an order. A presidential order can be issued wherein your right to move to court to claim your fundamental rights, except of course 20 and 21, they can be taken away. So this can be done by the President, number 1. And it's not the right being taken away. It's the right to claim these rights. Right to move to court has been suspended for a temporary period. Okay. So this is nonsense. Number 4, initiating the removal of VP. Yes. Article 67B, we know very well the resolution to remove the VP can be moved in the Rajya Sabha only. And in the Rajya Sabha, it requires a what majority? Effective majority. In the Lok Sabha, it requires a simple majority. So 4 is correct. 1, 2 and 4. Select the correct answers. So C, only 3 is the right answer. Right? Okay. Next question. With reference to the sessions of the Parliament, consider the following statements. Sessions. Adjournment terminates the session of the Parliament. Really? Adjournment terminates the session? No. Adjournment means sitting is over, not the session. Sitting. So 1 is wrong. The power of adjournment and adjournment sine die or sine die lies with the presiding officer. Yes or no? Yes, of course. Presiding officer adjourns the sitting for the day and will ask you to assemble the next day or any date that he or she decides. Adjournment sine die or sine die, both are correct. Adjournment sine die means when the date of next meeting has not been fixed. It's usually done on the last sitting of any session. This is correct. Number 3, prorogation. What is prorogation? From the word prorogue. Prorogation means terminating the sitting of the House for a specified time. Yes, that's correct. Prorogation terminates the sitting of the House for a specified time. Prorogation terminates the House, but not the sitting of the House. Session. Small word problem. So it's adjournment which terminates the sitting of the House for a specified time, and its prorogation which terminates the session of the Parliament. Okay, difference. And just to remind you, summoning a session, meaning calling a session, proroguing a session, ending a session, all these things are done by the President. Okay. And finally, number 4, dissolution is applicable in the case of Lok Sabha only. Yes, of course, Lok Sabha is subject to automatic dissolution at the end of 5 years, right? Which house will not be dissolved? Rajya Sabha. And that is why we call Rajya Sabha as a what? As a continuing chamber, because Rajya Sabha is not subject to dissolution. Few members keep on changing every how many years? 2 years. 1/3 members keep on retiring every 2 years. So it will never happen that at any point of time the entire membership of the House is gone. No. Few members, right? So it's called a continuing chamber. So 4 is correct. How many statements are correct? Of course, we know 1 and 3 are wrong, 2 and 4 are right. Right answer is B, only 2. Next question. What amongst the following is a special power of Rajya Sabha not available with the Lok Sabha? Special power of Rajya Sabha not available with the Lok Sabha. So voting on demand for grants, this is a special power of Lok Sabha. Introducing a privilege motion, this can be done in any house. If any member breaches the privilege of the house, this motion can be moved. So it's either house. It's not that it's some special power of Rajya Sabha only, which is not given to Lok Sabha. That's not the case. See, introduction of a private member's bill. Private member's bill can be introduced by a non-minister, whether Lok Sabha or Rajya Sabha. That does not matter, right? The point here is that who is introducing a bill. So we have non-ministers in the Lok Sabha also, in the Rajya Sabha also. So this again can be done in either house. This means none of the above. D is the right answer. Next question, which of the following parliamentary terminologies is or are correctly defined? Expunction. Deletion of words from the proceedings or records of the House for being defamatory or indecent by an order of the presiding officer. Expunction. The words are being, we use a term called expunged. Expunged. So basically, the Parliament keeps on publishing a list of unparliamentary words. Those words which should not be used in the House, because those words do not suit the decorum of the House. That's why. In case you utter such a word, then the speaker or the chairperson will instruct that those words will be expunged from going on the records. Or if you speak without the speaker's consent or the chairman's consent, then that also can be expunged, can be removed, can be deleted from going on the records. Yes, one is correct. Adjournment sine die, as we have discussed earlier as well, it's termination of the sitting of the House without any definite date being fixed for the next meeting. Absolutely correct. When the date of next meeting is not fixed, we call it sine die, adjournment sine die, and normally it's called adjournment. And who issues orders for adjournment or adjournment sine die? Presiding officer. Number 3, casting vote. So what's a casting vote? Casting vote is a tiebreaker vote. The vote cast by the presiding officer in the case of an equality of votes on a matter. So casting vote is called a tiebreaker vote. So we know very well that our presiding officers or anyone who is presiding over the session, over the sitting, is not allowed to cast his vote. However, in case of a tie, the presiding officer gets a casting vote. What is that? Tiebreaker vote. Because now, if let's say 200 MPs have said yes on a proposal, a bill, and 200 have said no on a bill, then if the speaker now gets a chance to vote, his vote is a decider, a tiebreaker vote. So all three statements have been correctly defined. C is the right answer. And we have the last question for today. In which of the following matters do the powers of the State Legislative Council equal those of the State Legislative Assembly? Introduction of money bills. Sadly, no. This is a power of Legislative Assembly, not the Council. Number 2, removal of the Council of Ministers by a no confidence motion. NCM is brought only in the lower house or the directly elected house, the Assembly. Number 3, approval of ordinances issued by the governor. Yes, that's correct. Ordinances have to be placed in both the houses. And number 4, enlargement of the jurisdiction of the SPSC. Absolutely correct. Such proposals can be brought in either house. Article 321. Right answer is D, 3 and 4 only. That brings us to an end of our session for today. So we have seen a lot of questions on legislatures. Now I would request you that once you have seen the video, I have marked various articles and various topics. In case you have not been able to solve any question or you did not know any fact or information or the articles, 2 tasks. Number 1, please read the article from the bare act of the Constitution. You can download the PDF online from the website legislative.gov.in. Read the article, Google search for it on your own. Number 2, selectively revise that topic. Let's say I asked a question on money bills and you got completely confused on the provisions. Please selectively go to your topic money bills, revise that. So in the last few weeks before the prelims, selective revision becomes more important, right? You cannot start from scratch every day. You have your revision plan, but once you take a mock test to solve any question, and if you're not able to recollect any of the options also, see, the idea is not to score marks here. The idea is to score marks in the examination. So let's say you knew this option, and you somehow got the answer correct. That does not matter. If you did not know the other options, please selectively go and check for the information, revise that portion selectively. Let's say you have made some error in the question on amendment. Please look at the provisions for Article 368. Because UPSC has the habit of asking questions from certain areas only over and over again, right? So that is it for today. Tomorrow we'll be back and we'll be discussing more questions, this time from judiciary. So you can take some time, devote some time into revising the topic judiciary, Supreme Court, High Courts, the lower courts, topics like the Gram Nyayalay, Lok Adalat, etc. Right? So that's it for me, guys. Let's meet tomorrow. Till then, that is all for this video. Jai Hind.